In today's lecture, we're going to be looking at Chapter 4 of the text concerning juvenile courts, the juvenile court system, how it's separate from the adult system, and some of the history of the formation of the juvenile courts. So 100 years ago, there really weren't any juvenile courts. During that time period, really throughout the first half of the 1800s, really into the second half as well, children were basically seen as property. They had very little rights, very little recourse against mistreatment, wrongdoings on the part of their parents or their guardians. It wasn't really until their rights were argued in court as that of animals. Things like horses, oxen, beasts of burden had fairly robust rights during this time period. Let me just turn my ringer off before that goes off during this. So to get children the rights that were afforded to these animals, attorneys basically had to argue that they were animals, and that got them the first semblance of rights. Now you had some people working from that side, you had other people working trying to open up orphanages, houses of refuge. Alexander Hamilton's widow did that, tried to open institutions for orphans because her late husband was himself an orphan, trying to better the opportunities for wayward youths. A lot of this and the system itself operates under this mentality of parentis parte, and it's something you may have heard said kind of offhand in a film or in a news account of a juvenile justice related issue. And it basically means that the state has a duty to protect the children in it. There's a duty of the state to act as a parent when there is not one that is capable or willing. There are many differences from the adult system and to the juvenile system. It's not a system of punishment. It is attempting to be truly a system of corrections, trying to prevent the behavior from continuing or evolving into full-fledged adult criminality. The goal is helping the child, helping them to address whatever issue caused them to commit the wrongdoing. It's also a much more informal system. There are less records kept, so that those records could then not be later used against a child that is adjudicated by the system. Oftentimes, really in almost all cases, the records in these cases are sealed. They can't be used in adult proceedings. The whole system and the processes are really based off of the system that we have in the civil court system. Again, less of a beyond reasonable doubt, just sort of trying to figure out what happened. Again, the proceedings are often sealed. It's kind of a trope in film and television that the police officer was able to get the juvenile record of the potential offender. That doesn't really happen. Those records are sealed, very hard to get, and even if a police officer was able to obtain a sealed file, any information that they then gleaned from that would be inadmissible in court because it was based off the illegal review of the juvenile court proceedings. One other major difference between juvenile court proceedings and adult court proceedings, is the absence of juries. Juries are made up of the peers of the accused. We can't really panel a jury with middle schoolers or high schoolers. So it's just basically bench trials. There's only the judge and not the jury in the juvenile court system. Again, it is, while it is part of the larger court system, they do try to keep it separate. It's part of the family court system, but they want to keep the people that are in different aspects of that court system separate. Someone in a custody dispute doesn't need to be housed with a delinquent offender. So it's part of these systems, but it is efforts are made to try to keep the juvenile justice system in that, the part that adjudicates delinquent offenders, status offenders, separate from other aspects of the family court system and also from other aspects of the trial court system to avoid the interaction with adult offenders. So having any kind of specialized branch in public works is going to leave um, that element, that court in this case, susceptible to things like financing, having a lack of um, manpower to staff these facilities, to staff these courts. Judges' caseloads can get overworked, so it is difficult. It's difficult to run any sort of um, segmented aspect of the criminal justice system because all aspects of the criminal justice system are very beholden to things like funding, resources, and the training and implementation of specialized personnel. So, as I mentioned before, there are several different types of individuals that are processed by the juvenile court system. The first, and probably the one that the system is most associated with, is juvenile delinquency, where juveniles, individuals under the age of 18, 17, depending on what state you're in, um, commit crimes that would be crimes even if they were adults. Theft, robbery, even serious offenses, homicide, things like that. Status offenders are individuals, juvenile offenders that commit an offense, but their guilt in that commission is only based on their age. Things like truancy, staying out past curfew, um, being labeled, insubordinate or incorrigible by the parents, and then being processed by the system that way. So the actions that are being taken by status offenders are less serious. Again, more tied to their immaturity, their age, and the restrictions that we place on individuals that are around that age, and their unwillingness to cooperate with those restrictions. Less serious offenses. Additionally, the juvenile justice system, the juvenile court system, also processes children in need of supervision. People who are either orphaned, neglected, going through custody disputes, those types of things. And because of the nature of the system, oftentimes there's sort of organizational spillover that the same judges are hearing all three types of cases, just depending on the resources for an area, what their ability is to hire, again, have more specialization within the specialized field. But the goal of the system is really to keep these three categories separate from one another, particularly keeping the children in need of supervision who are not criminal at all and not delinquent at all away from the other two. Particularly with housing juvenile offenders, it's very important to keep the status offenders away from those convicted of juvenile delinquency to avoid that sort of prisonization effect. So depending on what state you're in, and as you can see in the textbook with the charts detailing the issues of age with regards to the application of the system, it's pretty much all over the place. Depending on what state you're in, is going to play heavily into what the outcomes are for an individual situation. Typically, there is an upper age of jurisdiction that the court has, depending on what the offense is, and a lower age of jurisdiction. Typically, that lower age is between 6 and 7. Below that, depending on what state you're in, an individual is not going to be charged with a crime no matter what happened. It's just we have an understanding that individuals below that age don't have an ability to appreciate the longevity of their actions, the impact of their actions, so they're not held to account. In addition, there is the consideration that needs to take place once that individual has hit that upper age of jurisdiction, but their sentence hasn't been concluded. Depending on what state you're in, again, you can look at the chart and the text. The court can still have say over what happens to that individual in the system. In California and some other states, it goes up to the age of 24. So even if the person committed an offense when they were 14 or 15, depending on the seriousness of that offense, the juvenile court could have jurisdiction over them until the sentence is finished. Some states even have it be that the juvenile court system hears the case until the sentence is concluded. So if the individual were to receive through the juvenile court system a very lengthy sentence, that same court system could have basically control over what's happening in that case for a very long period of time. So there are some cases that get transferred to the adult system, and that's basically what a transfer means. A couple different ways that can happen. The first is judicial waiver, where a judge basically says that this case needs to be moved into the adult system. It could be a prosecutorial waiver, where based on the laws of the state where the crime was committed, the prosecutor has the decision of whether or not to seek adult charges. It could be out of the hands of the prosecutor or the judge, and it could be built into the statutory laws of the state. If an individual that is X age commits Y offense, then they must be charged as an adult. There are more and more of those laws being created really every year as we move probably towards a more due process model within the juvenile justice system. Additionally, there's the issue of automatic waivers. This typically happens when an individual has been charged as an adult in the past. The notion being that if they've been charged as an adult in the past, they should be charged as an adult in the future. It just depends on what state you're in, whether or not that's going to apply. And then there's also the reverse waiver, where the judge in the adult court does not feel that the case is warranted to be heard in that venue, and then will issue a reverse waiver back to the juvenile court system. As you can see in the flow chart in the text, only about 1% of cases that are brought into the juvenile justice system actually are transferred to the adult system. So it's a very small proportion of cases that raise to the seriousness of being transferred out of the juvenile justice system. There have been several advancements in the application of due process in the juvenile justice system. The earlier ones dealt mostly with the application of the constitutional rights, the same rights as an adult, proving the same elements of a crime. Again, it just sort of as these issues came up over the past 50 to 70 years, as these things come up, they are addressed by the court, and then the system is refined. We also see some things like the Juvenile Justice and Delinquency Prevention Act of 1974, which explicitly put into the system that you have to keep status offenders away from juvenile delinquents, again, to avoid that prisonization effect. The joke in the movie Blow was that he went in with a bachelor's degree in marijuana and he came out with a PhD in cocaine. That really happens in prison. The prisonization, the learning of skills, the social learning processes that take place really do happen. So it is important to keep juvenile delinquents, juvenile offenders that may be committing less serious offenses, away from those that might commit more serious offenses. And then we also see restrictions on the application of death penalty in Roper versus Simmons. No one can be charged with no one can be executed for crimes committed under the age of 18. Full stop. Additionally, you cannot sentence an individual under the age of 18 for crimes committed while they're under 18 to life without parole unless a death has occurred in the crime. Further limiting that application, even in the event of a capital murder where the only punishment is either life without parole or execution, as it is in Georgia, that does not apply to the juvenile justice system. There has to be a sentencing hearing held if life without parole is to be applied, even in the case of capital murder. So again, just more steps trying to give the youths every opportunity that they have, the system can't afford them to try to turn around what's happening. The individuals that work in the courthouse play slightly different roles. We've talked a little bit about these through the first couple chapters. We'll talk more specifically about what the roles of these individuals are throughout the later chapters in the adult system. But looking at them here in the juvenile system, judges play a more robust role. Again, with the absence of any juries, they're the ones that are going to be deciding all of the procedural aspects of the case, but also the ones deciding guilt or innocence. Additionally, an individual that's not really in the adult system is the hearing officer, which again sort of lends the informality of the process. If they are not trying to have a formal record being kept, again, this is an individual that can make informal recommendations to the judge, which can then be sort of formalized, really just suiting the needs of the cases as they come up. Prosecutors play basically the same role as deciding what charges to bring, although they're supposed to be more open-minded in determining what the outcomes are to the plea bargaining process and things like that. Defense attorney is the same thing, serving the needs of their client. Again, it's a little bit different than just, you know, the adult defense attorney is just trying to get their client to be not convicted. In the juvenile process, they might work more with the prosecution's office than they would in the past to discuss things like the home life of the child, what brought them to these situations, as opposed to just, again, trying to basically fight a fight to have them not be convicted. And then probation officers, again, they serve a more serve a role that's less harm management and more hands-on than it is in the adult system. They have still overloaded, but they have smaller caseloads. But again, the goal of trying to reform the behavior of the youth instead of just trying to seek a punishment. So the steps in the process are they're called different things, but it's very similar to the adult process. The delinquency, the crime that takes place, the summons is basically like the arrest, intake, detention hearing, petition, and conference are really your initial appearances, preliminary hearings, looking at what the home life situation is for the individual. Are they going to be released? Are they going to be held? There's not really any bail in the juvenile justice system, so they're either released to their guardians or they're held in detention. So again, those sort of pre-trial processes. Then we move into the evidentiary hearings, similar to what happens in the adult system. Motions can be made for exclusion of evidence, although again, it's more based on trying to find out what's going to be best for the youth in this case and trying to figure out what happens going forward. The plea bargaining process, again, is during the same time as it would be in the adult system. There's more of an emphasis on the prosecutor to accept a plea bargain, to work towards something that might offer positive effect on the offender's life going forward. But it really just depends. The adjudication hearing is basically the trial. Again, without a jury, the cases are presented to the judge. Then they make a ruling, which is a disposition, not you're not convicted. You have disposition where you're adjudicated one way or the other, and then the appeal process. And as we've seen in the previous slide about the application of due process, there isn't an explicit ruling from the Supreme Court giving juvenile offenders the right to appeal in any case, but a lot of states sort of smelled that coming down the line and have built that into their own systems, giving offenders the right, juvenile offenders the right to appeal in any instance. Going forward, from a due process model, from a crime control model, we see more of an application of waivers to adult court when high-profile events take place, when a juvenile commits a murder or commits other high felonies, serious violence, high-level drug trafficking, things like that. There's oftentimes a public push to have those transfers, to move them to the other court. But that's not the point of the system. And those knee-jerk reactions really do more harm down the line than they do to... Definitely, they don't do anything to affect the change in the case that already happened. It's just, it's vengeance, and vengeance is very bad for policy making. From the due process side, what we've looked at is trying to work more with crime prevention, trying to identify at-risk youths earlier on and reduce the likelihood that they're going to engage in antisocial behavior. Keeping kids occupied, giving them role models to look up to, giving them goals that they can achieve. Those things can be very important when a potential offender is living in, a sort of a hopeless environment, worried about if they're going to have food tomorrow. Um, they're not really worrying about what type of criminal behavior patterns they're falling into if they're hungry all the time. So crime prevention is really a social services issue that needs to get a lot of attention, and it can really have a wide impact on positive outcomes and reducing negative outcomes in the future. So be sure to watch the linked video about the juvenile justice system, seeing it sort of in operation, and it might be good to have a tissue or two near you towards the end. It gets pretty raw. But just make sure you watch that video and you can contextualize some of the things you read about in the text with what the system looks like actually in practice.